So if the court doesn't mind, I'm going to start with the statute and just go through it, identifying the features that we submit are relevant. And I'd like to do that from the authorities volume 1, behind flag 1, starting at 415. So here we have section 67, the obligation to appoint an election agent. That has been a key feature of election legislation because he is the central figure through whom all payments must be made and in respect of whom the vast bulk of the expenses incurred must also be routed through. And that is a feature of the election scheme which is followed by the Political Parties Act. So you have an equivalent obligation on a party to appoint a treasurer, section 24 of the Political Parties Act, and you have an equivalent obligation on a third party to appoint a responsible person, section 85 of the Political Parties Act, and an equivalent for referendum. Again, they're called responsible person, and that's section 105. So you've got exactly the same feature in each of these schemes, that there is a singular figure identified. Treasurers, I should say, are allowed, sub-treasurers under section 74. But other than that, there is always one person who's required to be identified for the purpose of carrying out the duties under the Act. And then I pick up the duties under the Act, and starting at 420 with 71A, the obligation in relation to all of the schemes is that any donation, and obviously notional services will normally be donations as well, must be provided to the agent or to the candidate. That's 71A1. (71A2) assumes that there will be expenses lawfully paid by someone else, but that will be a doubtful category if the appellants are right about the effect of notional expenditure. But I'll leave that for the moment. But any person who provides money in contravention of one, in other words, doesn't provide the services, property, etc., commits an offence of illegal practice. Next page, 421, payments.
Is donation defined anywhere other than here?
Yes, it's given an extended definition in Schedule 2A in paragraph 2, which is 460.
In any event, this actually doesn't use donation except in the heading. It's
yes. But it
money or other property provided.
It includes services, facilities, property, etc. So it catches all the things that would be caught by the notional spending provisions. So that's paragraph 2 of Schedule 2A.
But this must only apply to reimbursement of actual election expenses incurred by the candidate or on behalf.
Your Lordship says that, but I don't believe, given the width of the definition in Schedule 2A, that can be right. But you've got 2A here in the bundle, beginning at 461, and the definition is between paragraphs 2 and 4, 460 to 461. Do you mind if I don't get diverted by that? Because there are probably clearer points which, if the appellants are right, create confusion, and if we're right, appear to work perfectly properly. So
it was your passing remark that
yes.
All the 90C activity would necessarily be a donation as well, that I was just trying to check out.
I understood, and it's because it includes goods and services provided by way of gift for the purpose of meeting election expenses.
Services?
1A is 1B, 71A, B.
71A 1B, is that right? Yeah.
Services?
So,
The services
It's a
they come in via paragraph 2 of Schedule
yes,
2A,
yes,
which defines donation.
yes.
Where is the word donation used, other than in the head note?
It's subsection 4, controlling donations. So I assume that they intended that should.
Well, it may appear somewhere in what you have to put in your returns, but I don't know.
It will appear in the return.
It's much more likely to be specifically defining something
Yes.
rather than this.
Perhaps I can go to payment because that is simpler. And I understand the Election Commission to agree with this. So 73(1), no payment shall be made unless it is made through the candidate's election agent. And that is also an offence, an illegal practice under subsection 6. So let's take Mrs. Bowman, who's rented the hall. And the candidate, who happens also to be anti-abortion, goes along to Mrs. Bowman's hall and says, "This is really helpful. Do you mind if I say a few words to the people so that I may have the benefit of your supporters knowing that I am also anti-abortion?" And he makes a speech. So she's provided it for his benefit. She intended to support him. He has made use of it. She has committed an offence by paying for it, because by taking its benefit and using it, he has converted it into election expenses, and she shouldn't have paid for it. It should have been paid for by the agent.
What's the chronological history of this section?
This has been amended, as you can see, to take into account the amendments in the Political Parties Act, because, as you can see, subsection 5 represents amendments that were made in the course of tidying up some of the incidental provisions. So you can ignore subsection 5, otherwise those are all minor expenses. You don't need to worry about them. So there's
Subsection 1 has also been amended, it appears, substituted by the same Act.
Yes.
So I suppose the question is, were they thinking here of deemed incurred election expenses, or were they just focusing on actually incurred?
Well, obviously, deemed incurred will always involve somebody else paying for them.
Well, that suggests they might have been focusing on actually incurred rather than the deemed incurred, doesn't it?
Well, the problem is that the deemed incurred doesn't appear to be exempted from this. And the same is true for 75, which is the prohibition on incurring. So 75, which is at 423, no expenses shall be incurred by any person other than the candidate, election agent, and person authorised. We know that that is, a contravention of that is an offence. We saw subsection 5 this morning, which is at page 425.
But what is the gist of the submission? Because, I mean, on the face of it, this looks inconsistent with the, if you apply it to the deemed provision in section 90C, it doesn't seem to work, does it?
No.
No.
So, I mean, the inference, maybe this one, section 75(1), seems to predate the 2000 Act.
Well,
So maybe it's part of history, and we don't know whether the predecessor, whether section 73(1) had a predecessor.
all of these have
Must have
predecessors,
had.
my lord.
Must have had. Well,
But-
without looking at the history, one can't really work out whether these two sections apply to section 90C type deemed incurred expenses or not.
My lord, as we'll see, both 90ZA and 90C get included in, and actually I can answer it in a much simpler way. What I'm saying for this Act is also true for the Political Parties Act. So I could go through the third party expenditure, indeed I may have to, and say third parties which started with the notional expense and the prohibition on payment being enacted at the same time have the same problem. So even if you try and separate this out, you're going to have to make a separate rule for representation of the people, assuming it's all a historical accident. But then you'll come on to the Political Parties Act, and let's just do that because just for fun. If you go behind flag 4 to part 6, which deals with third parties, section 91, which is at page 555 running over to 556, has got the same prohibition on payment. The section before 90 has the same prohibition on incurring. And all of that comes after the notional provision, which is material identical, which is section 86. So on the face of it, that they have a prohibition on incurring and paying, in which criminal liability is adventitiously visited upon anyone who has the misfortune to pay and then find that the candidate turns up and says, "Thank you very much, I'd like to use this." And what's more, the third party loses their right to expend up to £20,000 because, as I've already indicated, their expenditure defaults down to be candidate expenditure if that is how it's to be classified following the application of the notional payment. So if you go to section 87, it's still in the Political Parties Act, no amount of controlled expenditure shall be regarded as incurred in respect of an amount of expenses that falls to be included in return as to election expenses. So instead of getting, as effectively section 94 confirms, you go on to 559 and read over to 560 and 561, instead of getting the right to spend money in the case of a recognised third party in accordance with Schedule 10, which gives you a percentage of the national party limits, or in the case of somebody who's not recognised under subsection 3, the limit that's referred to in subsection 5, 20,000 for England and 0.05% of the campaign. Instead of getting that, you're liable to find that your expenditure, in fact, has the perverse effect of swelling the candidate's return instead of counting as your own, as well as committing the paying offence, obviously, and probably the incurring one. And it also, perhaps I just deal with this while we're here.
It provides for, doesn't it? In order to be caught by 90C and its various equivalents, it has to be provided for.
The benefit. But obviously Mrs. Bowman, when she goes down to Thanet and she knows there's a part, wherever, knows that she's going there to make sure you vote for Mr. A, I agree with reducing the right to abortion. Mr. A turns up and says, "Thank you very much, I really welcome you." And even more so, a fortiori, my lord, if one is Mr. Farage with your base in South Thanet, because the same rules apply to party expenditure. You've got the same problem with party expenditure, where you're saying, I'm going to spend UKIP money from my base here designed to support me and others, and I'm going to also spend my candidate expenses, and I'm going to make use of it all in projecting myself to the people of South Thanet as being a responsible MP. How are you going to separate that out? But there's a particular point on third parties, because if you're at at 94, subsection 6, this is the common purpose rule that I spoke about there being deemed incurring in different ways, depending on who your common purpose was with. And so you can see that that's dealt with by referring on to section 94A to D, and I just ought to just briefly show you that. If you go on to 94B, yes, I'm sorry.
But where's the reference to referring on to section 94B?
It's in relation to where the expenditure is incurred as part of a plan of arrangement with third parties and one or more other third parties.
So the deeming is in
passage
after the gap.
Yes.
Yep.
Correct. And it works in two different ways. Either under subsection 8, it works as it is between 94A and B, or it works as it is between 94D and H, and that's because there are two different sorts of deeming to be incurred, depending on which sort you are. And just by way of summary, I'm sorry this is detailed, but the court will understand that our ultimate submission is that all of this careful provisioning would come to naught if, in fact, the notional expenditure deeming something to be incurred is to be read in the way that's suggested. So there are two ways in which there is deemed to be expenditure for third parties. The first is where there is a 94A arrangement where you've got a lead campaigner and a subsidiary minor campaigner. And in that case, 94B2, all of the expenditure, whoever it's used by, and for whatever benefit, is deemed under 94B2 to be incurred by or on behalf of the lead campaigner. The second form of deeming is in relation to targeted expenditure, which is explained in 94D, which is at page 569. And you'll see that this deals with typically union expenditure, which is targeted at supporting Labour Party candidates.
It has to be targeted at a registered party.
Yes.
Yeah.
Yes. So it's, you know, and you might get, I don't know, some of the pro-Brexit pressure groups doing the same for UKIP. Yeah. But if it's targeted at candidates of a particular party, you can see that as a result of that, the expenditure under 84F, if it's unauthorised, then so far as it's targeted at a particular party, and it exceeds the limit, then it may be an offence. But 94F deals with the case where the targeted expenditure has been authorised by the party, and that authorised amount under 94F2 is to be treated as if it was campaign expenditure and as if it was incurred. Now, all of this is done with knowledge of the notional provisions. And indeed, it's even more stark if one looks at the equivalent common purpose provision in relation to the EU Referendum Act. And perhaps just to finish off this topic, to save me coming back to it, that's in the blue file behind flag 5. And it's paragraph 22 of Schedule 1, and I'm sorry that it's not paginated, which is my fault, but it's in the middle of that clip of documents, and it's paragraph 22, headed Expenses Incurred by Persons Acting in Concert. It's roughly halfway through.
Schedule.
Paragraph 22, my lord.
Schedule 1.
And the heading above 22 is Expenses Incurred by Persons Acting in Concert. So here we are, we're in the European referendum. There has been a designated permitted participant on both sides, and there are other permitted participants who have registered. Clearly, they're all spending for the benefit of their side of the argument and using and taking the benefit of other people's spending. Where those parties are acting in concert, which are referred to as common plan expenses in paragraph 22.2, in pursuance of a plan or arrangement, then there are two possibilities for deeming as to who's incurred them. The first is where they are simply permitted participants. 22.3 over the page, it's deemed to have been incurred by both, so the common plan expenses of the individual are deemed to have also been incurred by or on behalf of the other individual.
Counts against both.
Counts against both. But if one of them is a designated organisation, this is sub-paragraph 5, then it's deemed to have been incurred on behalf of the designated organisation only. And it's perfectly clear they're doing that without any idea that this may all be messed up by notional referendum expenses, because as you can see in sub 7, there's a specific reference to the fact that the notional provision in section 112 applies for the purposes of the Act. Section 1112 is the notional expenditure provision.
Where do I find that? I'm sorry, this is subsection 7.
Sub 7, my lord.
Thank you.
Because the truth is, until it was articulated by the prosecution in this case, nobody's ever realised that it was seriously contended that the notional expenditure provision was anything other than a means of deeming value. Because we accept it's a deeming provision, but it's about deeming the value to be ascribed to services. It's not about deeming who has incurred them. And none of this parliamentary scheme, which allocates particular people to have responsibility for having incurred it, is consistent with that. And none of the scheme, which I hope I've shown my Lord Mance, assumes people who are paying in contravention of the prohibitions takes into account the fact that notional expenditure may free them from criminal consequences if they're not authorised, or may visit them with criminal consequences if they did pay it, they were authorised at the point of payment, but ceased to be because of the notional exercise. So if I could go back, perhaps just to complete what I was going to say about, I'm sorry for dodging off, but complete what I was saying about the Representation of the People Act. So I'd got to section 75, the offence of paying expenses, at flag 1, page 421. So here we have the prohibition on payment. in respect of election expenses incurred. And in my submission, you cannot read into that other than notionally incurred, because it's not there in any of the other prohibitions on payment, which I should give you. So the equivalent prohibitions on payment in the Political Parties Act are 75 in the case of campaign expenditure, 91 in the case of third-party expenditure, and 114 in the case of referendum expenditure. They're all in exactly the same form, and none of them say, with the exception of notional expenditure.
What was the last one?
114, my lord, for referendum. And for what it's worth, Mr. Gordon has said, oh, well, you can go under Section 86 to obtain relief from the court. But 86 is only a remedy, Section 86 is only a remedy in respect of returns. There is no safety valve of being able to go to anyone and say, actually, I shouldn't be guilty of an illegal practice because when I paid, when Mrs. Bowman came along and paid for the hall, I didn't realise the candidate was going to blunder in and take the credit for it and say how anti-abortion he was. So, just turning on, Section 75 is the prohibition on expenses not authorised. And this is a prohibition on incurring. My lords, we make no apology for equiparating authorised from incurring. There has to be some mechanism that recognises the process of incurring. That is the language used by the Act. So unauthorised incurring is not permitted, and therefore we've said the other side of the coin, the obverse, is authorised incurring. It may be a shorthand which can be the subject of critical analysis by Mr. Gordon, but it demonstrates the difference. If you're unauthorised, you commit an offence. If you're authorised, you don't.
But is it, on Section 75, is a problem with your interpretation that actually the deeming provision in Section 90C can't apply in this context because the deeming provision deems expenses to be incurred by or on behalf of the candidate, whereas Section 75(1) is dealing with expenses incurred by any person other than the candidate.
Yes.
So why don't we just, Section 75(1), we just read literally, that expense is actually incurred, rather than dealing with notional expenses at all, because there's nothing to say that it includes any notional expenses.
Well, the problem is that so far as the offender is concerned, they will say, actually, it was incurred by these are not expenses incurred by somebody other than the candidate, because the candidate is deemed to have incurred them once he uses them.
Well, he may be deemed, it may be that two people incur them in different contexts.
But it's certainly...
But you've got to find something which deems them to be incurred by a person other than the candidate, and merely because they're deemed to be incurred by the candidate, if they are also, I haven't worked out the possibility of overlap, but you say there is one, doesn't mean say they're deemed to be incurred by someone other than the candidate.
Oh, but there are further problems with it. If you turn over, obviously 1ZB frees the £700 spender from that subsection.
Yes.
But as you will see, so far as they are concerned, the liability is that if theirs is treated as notional expenditure, it ceases to be their notional expenditure and becomes the candidate. So effectively, they will lose, well, unless they want to cost the candidate the extra £700 they're going to spend, they will have to recognise that if there's a risk the candidate may benefit from it and use it, they can't spend it, because it's going to count against him notionally.
Well, it's the same point.
It is.
Except that you say the whole point about the 700 exception is to enable someone to support the candidate.
Indeed. And for Mrs. Bowman to have the candidate come along and say, I'm the anti-abortion candidate here, vote for me. If she is prohibited from spending money that actually has any significant impact because she's not able to rope the candidate she favours in, what is the point in her expenditure?
Well, she won't be prohibited from doing it, will she?
No.
There's no problem about that. She doesn't commit any offence. The problem is that if there's a problem,
if it's a problem,
if there's a problem, it's that you give with one hand the power to add £699 to the candidate's resources, and you say
you take it away from the candidate.
With the other.
Yeah. In fact, the £700 doesn't mean
only if the other. Only if the other uses it. So.
Quite.
Yes, but my lord.
And so,
otherwise, why would you be doing it? If you're Mrs. Bowman and you want candidate A to be elected because they are anti-abortion, and you book your hall and you invite candidate A to come along and speak because that's your Article 10 right, and that's why the Grand Chamber decided the case as it did. What would the purpose of that be if in reality all you're doing is taking away £700 from his spending power? And indeed, this doesn't stop with Mrs. Bowman, because as I think I showed you very briefly, third-party national expenditure, there are even higher limits. So you've got a £20,000 right to spend in England if you're Mrs. Bowman, even before you register. And again, if let's assume that the people who support her views are all in a particular party, she wants to encourage their election. She goes down to their constituencies and spends her £10,000, as she's entitled to under the third-party campaign expenditure. And she's, again, got the problem. She's either taking it away from the party she wants to support or from the candidate because of the carve-out in 87, Section 87. And just by way of information, 75(2) in fact applies to a different category of spending, that is spending in excess of 700 where it's been authorised. The obligation to report, make a return in respect of the £700 is in Section 75ZA, but you don't need that detail.
Your reference to Section 87 was, where do we find that?
In Pepera.
In Pepera, yeah.
So it's the bit where you can see that third-party spending defaults down to, so 548, thank you. So the third party's got the right to spend 20,000, but if the third party does it in a way that then, under the appellant's construction of notional services, it's used by the party or for their benefit, then it becomes campaign expenditure.
Used by the candidate.
Yeah, or either. So if Mrs. Bowman says, vote Conservative because they don't like abortion either, and the party says, good old Mrs. Bowman, we like what she says, they lose the 10,000 she spent, or 20,000 in England. And if she says it of a candidate, vote for candidate A, he doesn't favour abortion, he loses his allowance to the sum of 10, possibly wiped out entirely, in fact.
That is because of which words?
My lord, no amount of controlled expenditure shall be regarded as incurred by a third party in respect of an amount that is regarded as incurred on behalf of a registered party, so that's campaign expenditure, or Roman 2, an amount of expenses included in a return to election expenses.
May, I suppose, have been deliberate, may it?
My lord, if that is so, it is surprising that you have the offences in the way that's suggested, because it means Mrs. Bowman can set out perfectly innocently to rent the hall or to have her advertising campaign and find it's adopted and used by someone else, which has the consequence not only that she loses her allowance, but also she commits the offence.
So her offence is?
Paying for the campaign. So if you go on,
Incurring, 75.
well, both incurring and paying. Paying is incurring is 90, section 90, page 555.
And I'm obviously being slow in this one, but if 87 has effect, so she's not regarded as incurring,
Yes.
what then? I mean, how would she commit an offence under 90?
It's probably only 91 that would be the offence. So she has... I'm sorry, no, so wherever it defaults to, so if I get it right, it would default to being an offence. If it's campaign expenditure that it's defaulted to, she'd be committing the offence under section 75. So she's paid the money up front for an advertising campaign in support of the Tories. It's defaulted to be campaign expenditure because of the notional expenditure, and it means she's incurred it on behalf of the registered party, because that's what the notional provision provides. And subject to reasonable excuse, 75(2), she's committed an offence. And 76(1), she'd commit the offence of paying in respect of campaign expenditure.
Sorry, 76.
76, 1 is the prohibition, and 76(4) is the offence.
You're in prepare, are you?
Yes. Sorry, my lord.
Five-
So I'm just assuming...
It's all preparing.
Yes.
532.
Yes. But depending on where it defaulted to, if it defaults down to campaign, this is the relevant provision. If it defaults down to election expenses, obviously it'd be the Representation of the People Act.
Unless I'm mistaken, all this is a bit summary in your case, which is not necessarily a bad thing, but
No,
I just wonder whether it would be helpful to have it slightly more explicitly set out.
well, certainly your lordships and my lady should have a table, clearly, that shows that the scheme. I've been offered a shorter table by my own friends for the Commission, and I'm sure we can... I actually have my own table, but so we can type that up, which will give you all the equivalent provisions. And I'm sorry you haven't had it.
I think for my part, what would be helpful would be if you've just tried to show by reference that table or otherwise the precise anomaly, which you have. I hope I'm not being critical, but you hinted at in your case, but
Yes.
not being very explicit about it.
Well, and my lord, I'm sorry, I was driven onto it, but I was driven to it by the suggestion that somehow one could interpret Representation of the People in some historical context where you could
Yes,
look...
well, you sidestepped and you looked at everything else. And,
because
it's
whatever the
problem.
court decides has to be correct for all these schemes because they're all exactly the same.
Yeah.
And you say history is only a certain amount of importance because these key provisions came in at the same time as Prepara.
Exactly.
Yeah.
Exactly.
Yes. Well, could you do that?
Yes, my lord.
Very much.
Could I, with that necessarily extremely long run-up, come to section 90ZA and 90C, which are back behind flag 1, 90ZA is at 445. And we made a number of points about this in our case, which I don't want to repeat, but it's effectively from paragraph 54 onwards, page 97. But we would submit that it's significant that subsection 1 defines election expenses and subsection 4, for the purposes of the Act as a whole, defines when expenses are incurred. So effectively 90ZA1 is dealing with types of expenditure and obviously includes notional expenditure. 70ZA4, we would submit, is dealing for all purposes with the circumstances in which election expenses can be regarded as being incurred. If you then turn on to 90C, which is at 446 and 447, this is, we submit, a provision that's required in order to deem an appropriate amount. That's what the deeming provision in subsection 2 is for. Not for the purpose of treating expenses as having been incurred in circumstances where the candidate may not even know about them. Firstly, your lordships and my lady might care to note that the only really problematic category of property is property that's provided free in the circumstances in Roman 2. And the reason I say that is because property that's provided free in Roman 1, A1, has to be transferred to the candidate or his election agent. So you've got a clear line of responsibility for that property. Property that's transferred at an undervalue under either Roman 1 or Roman 2 has to be property where the balance, the undervalue, has actually been incurred. And the reason I say that is because if the court goes on to look at subsection 4, so this is dealing with property for the benefit of the candidate at an undervalue. Subsection 4 says, where subsection 1A2 applies, the appropriate amount is, I'm going to go to B, the difference between the commercial rate and the amount of expenses actually incurred by or on behalf of the candidate. And that makes it clear in my submission that in all bar the free services for the use or benefit, the assumption is that this will always be property or goods that the candidate or the agents actually received or actually incurred. Which does suggest it's not doing the sort of wide-ranging anti-avoidance work that's been proposed, but it's instead contemplating actual incurring and then providing for that to have a deemed value. And that's what subsection 2 is doing. It's deeming the appropriate amount. And the only category, the only problematical category in that subsection A, therefore, is property provided free. And that is what the second half of 90C1B is dealing with. Because once you understand that goods as an undervalue have actually to be incurred, so that reads expenses are actually incurred, they would be incurred on behalf of the candidate. And in relation to the free provision, it is requiring something equivalent to incurring if any expenses were to be incurred. In other words, but for the fact you were getting it free, you would have had the responsibility for paying for it. Then those are election expenses incurred by or on behalf of the candidate. So it's dealing with that very narrow category of cases, and it's not dealing with it by reference to use, but by reference to the fact that obviously if something is provided free, then you can't, strictly speaking, be regarded as having incurred any legal liability to pay for it. And this is, as I think Mr. Gordon has already acknowledged, identical in form to that which is provided in relation to the other schemes. So the equivalent sections are 73 in Prepara for campaign expenses, section 86 for third-party expenses, and 112 for referendum expenses.
Could I just take you back to the headline submission on 90C?
Yes.
If I've got it down right. What your case is that what subsection 2 is doing is deeming the amount.
Yes.
And you contrasted that with a deeming of incurring.
Yes.
Where the candidate may not even know about it.
Yes.
Did I get that right?
And the reason for that...
No, just hang on a moment. Given the requirement that it has to be made use of by or on behalf of the candidate, could you just give us an illustration of the kind of situation in which you think it might happen that the candidate or his team don't know anything about it?
Yes.
But yet it's caught by 90C2.
The difficulty is that the difficulty of election agency. As Mr. Straker has rightly recognised, there is a body of election law mainly created in the House of Commons committees which used to deal with who is and is not an agent, which makes it perfectly clear that you act on behalf of the candidate in circumstances where you would not be a common law agent, and indeed the evidence wouldn't get anywhere close to proving that. There's a section in Parker's election law which, saving Mr. Price's blushes, were not written with this case in mind, which deals with the law such as it is on agents, but it's clear that as a matter of election law, the candidate is responsible for the acts of persons who could be regarded as his agents, even in, for example, this is one of the cases cited in Parker, a man came up to the election agent and said, "I'd like to work for you." He said, "No, I do not want you to work for me." But because he was allowed to keep coming to the committee rooms and because he was actually canvassing, the House of Commons concluded he was an agent even though his services had been refused. And the particular difficulty is that although you need to have an appointment of some sort deemed or implied if it's not express, that appointment can be by any other agent. So, and not just the election agent, sub-agents, exactly. So
is that necessarily anomalous, or is that simply a deliberate attempt to make sure that the candidate carries the can for his team?
Oh, the rules on agency certainly are there to make sure he carries the can for his team. But it means that if you're looking to say, is this the equivalent? Is this intended to make sure the candidate carries the can for his team? You've got to bear in mind what the impact of it is, because if it deems it to have been incurred, then you've got the obligation to report it in circumstances where it will simply be impossible for the candidate to provide the sort of detail that's required by way of declaration under section 81, which requires a detailed statement of election expenses within 35 days of the election.
I wonder if you're looking at the wrong route. I mean, you're focusing on authorization of expenditure incurred, but even if you look at the section 90 ZA,
Yes.
the focus is on, firstly, any matter specified in part 1 of section schedule 4A, which is used for the purposes
Yes.
of the candidate's election.
Yes.
In other words, the focus is on the activity, which is things like advertising, unsolicited
Yes.
material, transport, public meetings, accommodation, and administrative costs. So that all you have to have is use of one of those facilities, and then at some point, it might be after the event, if under subsection 4 the candidate pays for that, then that's an election expense incurred. So the parallel to that under 90C is the use by or on behalf of a candidate of property, goods or services, for which by definition no payment is made either in advance by agreement or after the event by concession. And in those circumstances, what it says is you identify the value which such use had and treat that as an election expense incurred, and as you say, then goes on to provide valuation provisions. But I mean, I don't see where you get the word authorization in there, but you may get quite a lot by a different route, namely made use of in each case. It's got to be something which the candidate, I mean, you said a moment ago that it might, the appellant's case might embrace things the candidate didn't know about, but that wouldn't be use by the candidate or on their behalf. And so you may get quite a lot similar to authorization in some contexts out of the requirement that the candidate should have actually made use of the services.
The problem is the usage isn't just by the candidate, it's on his behalf.
Or on his behalf, exactly. Well,
so it'll encompass use
so
by these agents.
Yeah, so it is, though, under
So he won't.
90 ZA.
Indeed, but ZA has 4 in it. So that it will not be. So that describes how a candidate potentially, this is saying these things, advertising that is used for your benefit, is capable of being election expenses. That's what 90 ZA1 is saying. But 90 ZA4 says, but they're not incurred by you unless you've personally incurred them or you've authorised them being incurred.
Well, that's the disbursement. But the actual services, I mean, you may have, somebody may have generously incurred a campaign expense, and when you discover about it later, you might authorise its reimbursement. That would be covered, wouldn't it, under 90 ZA? You don't have to authorise the original use.
Well, the person incurring it will have committed an incurring offence. And the reality is that your lordship route to say, well, he must have authorised it, can only work if one says you've got use by or on behalf of the candidate. That must necessarily imply knowledge or authority by the candidate. And it just doesn't. It doesn't value the words on behalf of the candidate in any meaningful sense. And if I could pose the rhetorical question, there are 2 possible pieces of work that 90C could do. It could just mean that you can give a value to make sure the true market value of things that are used by the candidate or by the party or by the third party or by the referendum are given their real market value. It could be doing that, in other words, it's a valuation provision, which is what the Neil Committee recommended. Or you could say it's actually doing something very complicated in relation to extended action, not just by the candidate but by his agents acting on his behalf, so that they are deemed to have incurred the expense. And that cannot be sensible given the impact it has on the rest of the structure of the Act and of the Political Parties Act, in our respectful submission. If both are possible meanings, then one has to bear in mind, was it the intention of the Political Parties Act, which brought in the Bowman right to make payments, which brought in the third-party right to intermeddle with elections and to spend money on them and to target expenditure on political parties to favour them, and yet at the same time was effectively rendering them as naught by the notional spending provisions, which meant they were not treated as being incurred by the people who truly incurred them, but treated as incurred by the candidate or the party. Because it's the on behalf of that causes the real mischief. And there's nothing there to suggest it can be read down in a way that renders the remainder of the schemes comprehensible. And for what it's worth, insofar as there has been commentary on whether 90C had the effect of overriding 90ZA4, as the Court of Appeal observed, certainly the editors of Halsbury, and I think I can acquit Mr. Price of being the editor of this particular bit, assumed that the rules in ZA4 about how expenses could be incurred remained intact. They were unaffected by 90C, and that 90C was deeming value, not incurring. And if your lordships and my lady want to look at it, that's in volume 2, behind flag 30, at page 1127.
What are we looking at? Where?
And it's it sets out the terms of 90C, and 3 lines up from the bottom, it having set out any expenses were to be or actually are incurred, they would be election expenses, footnote 15. And if you turn to that, which is at 1131, you can see that it says, for these purposes, election expenses are incurred on behalf of the candidate if they're incurred, 1, by the candidate or election agent, or 2, by any person authorised. So at the very least, the assumption was, by those commenting on section 90C, that it did not displace the requirement for actual incurring in 90ZA4. And as I say, that's been the assumption until this case was brought.
Who are the editors of this?
Well, Mr. Price edits the whole, but he didn't write this piece. So he did tell me the name of the author.
Well, surely it would be even better if he did.
But it's been intact for some time, as you will appreciate, this Act having been amended back in 2000.
But I mean, you say it overrides, but why does it override? All it does is by definition, a deeming provision deems something which to be the case which isn't actually consistent with the primary provision.
Indeed, but
it doesn't override it. It just
No, I understand, but what it's doing is providing a deemed value rather than.
Well, you say that, but that's subsection 2, not subsection 1.
Yes, my lord, the parties certainly think it's subsection 2, which is the deeming provision. That's their argument. Mm-hmm. It may be that they would, once you've said that, say, no, actually, we think it's in subsection 1. But certainly the argument up to now has been that the relevant deeming provision is 90C2. Whereas we would say the relevant deeming provision is 2, but that's dealing with value. And the only thing that is done by 90C2 1B is to deal with things that are actually incurred, that is the undervalue things, and things that were, but for the fact they're not paid for, incurred. So there has to be something that is functionally equivalent to incurring in circumstances where no obligation to pay arises.
1B is the bit that requires it to be something within the schedule as an election expense,
Yes.
isn't it?
Yes.
Without that, it would be
Yes.
almost anything.
Yes. So 90B says first bit, got to be an election expense, circumstances in which they would be election expenses, and second bit, incurred by or on behalf of the candidate. And there isn't provision once that happens for the sort of apportioning that is suggested. Because let's take expenditure by the party. Expenditure which is designed to support a particular candidate. That's permitted and that's within the definition of party expenditure. Or third-party expenditure, again, can be designedly aimed at a particular candidate. That's permitted under the definition of third-party expenditure. So it's undoubtedly going to be for the benefit of the candidate. Other than in an entirely artificial world, the candidate will want to make use of that permitted party and third-party expenditure. Did you see the wonderful election broadcast? Did you hear Mrs. Bowman's speech? But if he does that, all of it falls on his shoulders if this has the effect of deeming it to be incurred by him in circumstances where if it was a particularly expensive election broadcast, it might well just blow his entire budget just by that one act.
Is this a submission that 3 and 4, whilst they speak about proportion, are not about apportionment as between
Correct.
campaign
Correct.
expenses and candidate expenses?
Correct.
They're simply about valuation as compared with the full market value.
Yes.
Is that what you're saying?
Yes. And if you've used it, if you've used the hall.
But yes, as is reasonably attributable to the use.
Yes.
Doesn't that bring in the extent to which it is, on the one hand, campaign and on the other half candidate, or not?
I would respectfully submit not, but nobody so far has been able to explain why 90B, the general apportionment provision, was repealed. But on the face of it, that general apportionment provision is difficult to explain. And if
Sorry, the repeal of it.
yes, of 90B. You looked at it this morning.
But isn't apportionment inherent in 90ZA subsection 1? Because you're only talking about expenses incurred in respect of any matter specified in the schedule, which is used for the purposes of the candidate's election, so that
Yes.
it's inherent. And that's why you've got
Yes,
the Electoral Commission's guidance as
Yes,
to
but-
what counts.
Indeed, but let's take third-party spending. So a third-party well-wisher decides she's going to provide refreshment for a political hustings meeting, and she turns up with 700 cupcakes at £1 a time, 699 cupcakes at £1 a time. And the candidate turns up, he invites his supporters to eat the cupcakes. On the face of it, he has to account for that £699, unless he can say, oh, well, some of them didn't eat them, or only ate half, in which case it would be 500. But all of that appears to be use that's, or an expense that's attributable to his use of it. She loses the impact.
If he said, I'll buy all those cupcakes and give them to my supporters, or anyone who's here, that would be an electioneering expense, and if he's given them, it might be said to be the same.
If he's done the functional equivalent of incurring them, other than the fact he's not paying for them, yes. So if he said to her, give me the cupcakes, then you can see that is the conduct which we submit is intended to be caught by, if any expenses were to be incurred on behalf of the candidate, they would be election expenses. But it's got to be the functional equivalent of incurring.
Well, I think you're merging the idea of incurring expenses with the idea of using one of the activities for the purposes of the candidate's election, the activities set out in the schedule. And I mean, the language, one doesn't talk about incurring a service. What the Act talks about is about using goods or using a service. And then it talks about what may be accompany that or may follow, namely incurring expenses, paying for it. But it has to deal with a situation where you don't pay for it, and it then requires you to value the use you've made.
Yes, and the use is covered by the first bit, B, the property is made use of, but the in circumstances such that if any expenses were to be incurred, they would be election expenses incurred for or on behalf of the candidate, takes you back to ZA and the notion of there requiring to be specific undertaking of an obligation or authority to undertake that obligation.
Well, that's the question, isn't it?
It is, and part of the reason why I've taken you wider is I recognise that these sections are capable of being read in two different ways. Clearly, you've heard them read in two different ways. What I've tried to demonstrate is what we submit the purpose of this was, particularly in the wider context of broader election spending. Because it gets even more complicated once you're into, for example, referendum spending, where there are only two possible outcomes. People doing things in favour of your outcome, let's say Brexit, will be doing things that you'll want to use and take advantage of. Is that treated as being something that you've used, so you've had it a free service, so you have to report it? In our submission, that can't be right, and it can't be right in the face of the specific incurring rules that I've shown you that apply both in the ordinary referendum circumstances and also in the EU referendum circumstances. Let's take the EU circumstances, because they're very clear. You've got a permitted participant who spends within his limit, and you've got a recognised, a designated permitted participant who then joins in a common plan with him. And the designated participant then spends loads of money which the other permitted participant uses. So the designated participant gets loads of data, and the sub-participant then uses that data to do a lot of expensive polling, having not paid for it. Under the notional expenditure provision, he's used that for the purpose of promoting his cause, and it's deemed to be his expenditure because he's had it free and he's used it unashamedly. But according to the specific rules under paragraph 22, because it's a combination between a permitted participant and a designated participant, it's actually deemed all to have been incurred by the designated participant, the lot, all the expenditure. So it simply is inconsistent to say because the permitted participant used the services paid for by the designated participant, notional expenditure would say it's all his, but actually it's all going to be deemed to be back with the person who actually paid for it. And even more so when neither of them are designated, because obviously there, as we saw, they're both treated as having expended the amount. And the same with third-party targeted expenditure. So the court is entitled to come at this on the basis that the purpose was to give effect to the Neal Committee recommendation, which we've provided for you in Authorities Volume 2 behind flag 33. The relevant recommendation is at 1187. I'm sure the court remembers the circumstances leading up to this recommendation. And you'll see that under the heading items of expenditure to be covered, they take the view that they should all be covered, and they refer to the receipt of goods and services free of charge or at a cost lower than the real market value. There can be no objection to such arrangements, but the true cost of such benefits in kind should clearly be included in the accounts of the party in question, should count towards its total expenditure limit, and party accounts should itemise the expenditure in cash and the true value of expenditure of benefits in kind. So we accept that that is the purpose of these notional expenditure provisions where they appear. But in this, as in the Electoral Commission's guidance, the assumption is that what is being spoken about here are benefits or services received direct by the party or by the candidate.
Well, I'm sorry, I did look at the Neal Committee report
Yes.
a long time ago for a completely different purpose, but it semes to be aimed at national expenditure, not at constituency expenditure.
It is, but as you'll appreciate, it led to the notional spending provisions that came in for national, which as I've said, in relation to party, is in section 73. But what happened is that it was thought that it was right to extend that same requirement, true cost of benefits in kind received, across all categories of campaigning. So it came in at the same time to candidate expenditure and third-party expenditure. Because obviously what was being dealt with here was effectively party expenditure, but they go on and deal with third-party spending, and they say effectively that the same rules should be employed in order to cover third-party spending. So although this is dealing with the purpose of the notional expenditure provision in relation to parties, you've got the same across the board. It's just, probably time doesn't permit me to take you through, but it's quite clear that the Neil Committee also recommended that equivalent provisions should apply to third-party spending and to referendum spending.
Yes, your target isn't the notional spending.
No.
It's the inclusion within it of the overlap between campaign and candidate expenditure, which only applies to constituency elections and
Yes.
not to the other sort.
Yes. And the reality is that if 90C is read in the way we suggest, it is not an anti-avoidance, or it's not something that allows easy avoidance. Because in the end, as I hope I've demonstrated, if the free or notional thing was authorised, then it has to be reported. If it was not authorised, but incurred by someone else, then it's an offence. So on the facts of this case, there remain two possibilities, even if the spending doesn't fall to be election expenses under Section 90C. In the facts of this case, either it was authorised by the party, in which case it was campaign expenditure, or it was not authorised by the party and the candidate or the agent, in which case it was unauthorised expenditure and it would amount to an offence under Section 75(5).
Did Neil address the line between party expenditure and candidate expenditure?
He effectively did by saying, well, you can't really separate them out, because one of his observations was...
An observation somewhere about what else are they doing?
Yes, it's 1177 in the report. Why else are you spending it if you're not? And I think it's 1177. Yes, 1177. Given the British electoral system, what else could they be for?
So what's the paragraph number?
It's paragraph 1025 in the
Yes, thought so.
sub 2. And in the end, the big change that was made in the definition of election expenses from the original 19th century scheme was to allow for that overlap, and indeed to recognise that overlap by providing for expenditure to default down where you were in an area of common spending, because all spending, whether it's third-party spending, party spending, or election spending, is defined in a definition that includes procuring or promoting a particular candidate. So you can perfectly legitimately, as a party, let's take UKIP, promote Mr. Farage as a leader by spending party funds on him, and you can perfectly legitimately, within the limits, promote him as a candidate by spending election funds on him. The difficulty comes that if the appellants are right about 90C, all of that expenditure, because he's made use of it, falls onto his shoulders as an election expense. And obviously, I haven't given the court the figures, but I'm sure you appreciate the election limit is by an order of magnitude smaller than the limits given to any third-party campaign or party campaign. But there is no possibility here of avoidance. If the reality is that the payment is unauthorised, it's an offence. If it's authorised, then it comes within the limits, and failing to declare it would be an offence.
Authorised by the candidate?
Or by the election agent, or by somebody authorised in writing by them. Sorry, I'm not adding that rubric, but... Because otherwise, you will then go into the problem that bedeviled the earlier scheme, the 19th century scheme, where a lot of the cases which are in the bundle are all about, well, was it intended when publishing anti-socialist propaganda that they would harm the Labour candidate in the constituency where the pamphlet was put out, or was it the purpose of the person putting out the propaganda to produce that effect? And that would, in my respectful submission, be a source of confusion and doubt in circumstances where, on any view, the timings involved in election reporting and returns are very short and require accuracy. And it doesn't help that the candidates come first and the parties later. That just doesn't give you the ability to reflect potentially unknown and, if not incalculable, at least involving calculations that may have very great difficulty attaching to used by or on behalf of.
Are there party limits applicable to by-elections as well?
Yes, but
They're smaller, presumably.
sorry, actually, let me correct that. So the answer is no. I think there are no party limits. You get a higher allowance for the by-election.
You've only got one by-election, which may be in a particularly critical place. Quite a lot of national resources may find their way towards it.
But you get a higher limit.
The candidate does.
The candidate, yeah. So typically
There
it's around
it is,
100,000 as
just
opposed to
the
30.
candidate,
yes.
is it? So it's only general elections when I say only, but it's general elections
Yes.
when you have the
two together.
The two
yes.
together.
Yes. And you're talking about a massive difference, obviously. So you're talking about 18 or 20 million for the party and 30 to 40.
35,000.
Yeah. And obviously, that 18 million is being spent for the benefit of the candidates. Why else are they spending it? So, just to make the point, if I can, about the need to make returns. The court has seen the centrality of the role of the agent. Only the agent is permitted to pay. And this is echoed through the other schemes, so I don't want it to be thought that I'm limiting it, but the agent or the treasurer or the responsible person is the only authorised paymaster. So no payment for any campaigning, I use that in the broadest possible way, no payment for any campaigning activity can be made by anyone other than the identified person. And that does create problems. Now, it may be that in some circumstances, the person who paid, who had the misfortune to find the notional expenses bit on that, would say, I've got a reasonable excuse. But it cannot be a sensible statutory interpretation that starts from the presumption that you cannot pay for something that may later turn out to be a notional expense without running the risk of having to satisfy a court that you had a reasonable excuse. And indeed, it cannot be sensible as long as that payment is going to be treated as a donation, as it is, because there's a very elaborate scheme, which time does not permit me to go into, and your court may be pleased to hear it, which not only requires you to receive the donation personally, so we saw how the agent has to receive the donation The same is true of the treasurer of parties. The same is true of the responsible people in elections, in third party and referendum activity. But they also have to understand what it is, who it's coming from, and whether or not the person it's coming from is somebody from whom they can take a donation, or whether it's liable to be returned under the fairly complex rules that now attach to donations. And yet this whole idea of notional expenditure carries with it the risk that the agent is not only required to account for payments for the cupcakes that he didn't even know had been paid for, but he's required to say who paid for the cupcakes and were they an acceptable donor. So if each of these responsible people are, in the phrase used in, I accept a very old case, but adopted recently, are the sole legitimate paymasters for a good reason, because they are the people who are required to account for it both as donations and as expenditure, then the 90C rule makes their job impossible. And although I have no brief to criticise the Election Commission, the reality is, even read as a whole, there is nothing in their guidance to suggest that you have to value expenditure that you have not authorised if someone on your behalf has used it for your benefit. Indeed, on the contrary, although I've been chided, or maybe worse, by Mr. Gordon, I couldn't work out the depth of feeling, about using the word authorised, the reality is that authorised is the synonym used by the Election Commission in its guidance to explain to candidates what's involved in incurring expenses. So I'm just going to give you one little excerpt, which is behind flag 21. You don't need to turn it up unless you want to, at 977, where they say, 438, only certain people are authorised to incur election expenses: the candidate, the election agent, and any other person authorised in writing.
That's 94.4, 90ZA4, isn't it? Well, and elsewhere.
Yes,
and
yes,
elsewhere.
yes. Yeah. And certainly in terms of the advice on splitting, there is nothing in the advice on splitting which explains that you have to value things that somebody else might have provided if you have used it. All of the advice on splitting, and again, time doesn't permit me to go through there, deals with things that are given to the candidate, not things that are given for some other purpose and simply used adventitiously. So all of the references, I think, throughout their guidance, say words to the effect of, this notional expenditure covers items bought or given to you free of charge. You being the candidate. So we do submit there are a number of consequences that would flow from the construction that is proposed, even if it's a possible one. it would render, we submit, the limits on spending between the various categories entirely uncertain. And in some cases would simply destroy the distinction between the two forms of spending. I've given you the example of Mr. Farage's own spending in South Thanet as against the UKIP spending. It would mean, insofar as any candidate embraced the support of a third party, that they would then be burdened with potentially having to bear the £700 if it's 75(1)ZZB spending, or even £20,000 if it's Section 87 spending. It would render the requirements to report and assess donations, and more importantly, to receive them directly, unworkable. And it would potentially upset the careful allocation of who incurred expenses in the common plan or common purpose provisions. And at least up to now, all of this would have happened against the background where no guidance was given to that effect by the Election Commission. Now, I'm not saying they aren't capable, as Homer was, of nodding, but in the circumstances, it is surprising that guidance has not been promulgated, making it clear that if candidates use, either themselves or through their agents, any third-party spending or party spending, then they're liable to account for it as if it was their own.
Isn't there some guidance to that effect in what you referred to a moment ago, 221 at MS 979 to 981?
That's in the guidance for a by-election.
Yes.
The one that's in the guidance for a general election is a little bit later on.
Yeah, well, thank you.
Indeed.
I mean, obviously, there is a different problem.
Yes.
Yeah.
But they both deal with returning notional expenditure.
Yes, but as I say, in all the party and candidate general election, they all describe things that you have received. There's no suggestion it's things that you may not have received, but somebody else has used in circumstances where it's used on your behalf. As I say, it's along the lines of given to you free or paid for.
Valuing free or discounted items.
Yes. Now, in the end, if it's right, then clearly it will have very serious consequences for the limits. Because on one view, if it's right, a candidate who does anything that embraces national activity meets Theresa May when she comes down to his constituency, says, "Can I walk around with you, Prime Minister, and say, as I walk with you, please vote for me," will be running the risk of being treated as having had the benefit of her presence and her train ticket and her
It's
overnight...
only a problem if there's a train ticket in a hotel room, isn't there?
Yes. It will rewrite election law. It may be that the court is driven to the construction that's contended for, but in our submission, it will require a re-evaluation of the way in which election candidates interact with any party member coming to their constituency. And any third-party campaigner seeking to support them, because of the danger that interaction will give rise to the inference that somebody, either the candidate or somebody on their behalf, made use of it. And you only have to picture a typical general election day to realise that there is a wealth of party activity, not just the Conservatives which are caught up in this case, but all party activity which descends to constituencies, which is intended to benefit the candidate in that constituency, where the agent secretary has said, yes, please come down, we'd be delighted, we can make use of you at our meeting. And suddenly you're into having to account for all the expenses attendant upon that visit. But the most important point I would urge the court to bear in mind is that however you construe 90C, you will also be construing the other and determining the effect of the other notional expenses provisions, many of which will throw up even more difficult issues because the person on behalf of whom the use may be made is expressed in much wider terms. So, for example, in relation to third parties, there the notional expenditure is in section 86 at page 546 in Preparer.
I'm sorry.
So I was just looking at the notion, yes, 546, section 86 of the Political Parties Act.
Thank you.
So there you've got benefit of the third party, and then 86(1)(b would make it incurred by that third party, provided only that it was made use of on behalf of the third party.
By or on behalf?
Yes. So with campaigning organisations, which are the typical third parties or small political parties, you have an even wider range of persons who might be regarded as acting on behalf of the third party, where their usage will then require and place an obligation and indeed the risk of prosecution on the responsible person, who may be somebody entirely different, who has to make a return under section 96. And the reason I give the court that caution is clearly it would be tempting to regard the submissions of Mr. Straker as making a certain sense in the context of candidate expenditure, but it really ceases to make any sense once you look at it in terms of much more widespread activity, the sort of activity that you get in third-party campaigning, where somebody on behalf of that third party may do something where the centre, the responsible person, has no means of knowing that's happened. And the same for referendum. Now, I think that is all I wanted to say. Could I just check behind me, and obviously I'll answer any questions that the court may have.
So you don't need your extra 2 minutes.
I don't. Mr. Price may take it, but I don't.
Thank you very much.
I never refuse an invitation just to take up a couple of minutes of the court's time. My points will be very short, and they are simply to refer the court to MS page number 84 in our case, where you will see at footnote 2 at the bottom of the page a summary of the Electoral Commission guidance that is in the court's bundles, and the summary there explains the various times when advice has been given that are relevant to this particular election, and the court has Ms Montgomery's submissions as to the fact that there was no advice given in relation to the construction for which the prosecution now contend. In the additional bundle of documents, the court will see the guidance for the 2018 local elections, where the guidance is very much the same as it was in those earlier pieces of guidance to which the court is referred in footnote 2. The only other footnote that I would refer you to in the case, which is at page 97. I'm not sure whether the court appreciated this, but the police investigated over 25 Conservative members of Parliament and their agents in respect of battle bus expenses. And on the 10th of May 2017, as is set out in the footnote, the CPS issued a statement, page 41 of the bundle before the Court of Appeal, in which it was stated that it was, and I quote, clear that election agents were told by the Conservative Party headquarters that the costs were part of the national campaign, and it would not be possible to prove any agent acted knowingly or dishonestly. Thus, no charges were preferred in those cases. I just thought I'd bring that to the court's attention. And in conclusion, and having regard to the time, it is our submission that if the prosecution construction of the two sections is correct, then the role of election agents for all political parties will be undermined because they would no longer retain control over their campaigns. They would not have power and control over incurring the costs for a campaign, preparing their budgets, and overseeing payments of election expenses, unless their authorisation was required for election expenses to be incurred. And similar problems would apply to the other types of expenditure to which the court has been referred, in other words, campaign, controlled expenditure, and referendum expenditure. That is all I seek to add.
Thank you very much, Mr. Price. And what about Mr. Gibbs? Does he want to add anything?
My lady, on behalf of Mr. Gray, may I simply adopt and endorse all the submissions that have been made by my learned friends, Ms. Montgomery and Mr. Price.
Thank you very much, Mr. Gibbs.
Much obliged, my lady. May I first refer to the request that was made of me this morning by my Lord Hughes and the discussion that took place referable to agents. Can I seek to be absolved from the task that was descended upon me by making the suggestion that the relevant extracts from Parker's electoral law on agents be submitted to the court?
Yes.
Good enough for me, certainly.
I'm much obliged.
I think it was my request, in fact, rather than Lord Hughes.
Oh, I do beg your pardon. I'm so sorry, my lord.
I think you both asked for it.
Yes.
And the rest of us nodded sagely.
My lord, there's always a sage nodding. The position as far as that is concerned, though, I just add, if I may, is that plainly the relevant language used in the relevant provision is on behalf of, and I would respectfully submit that anybody directing a jury in connection with these matters would stick close to and ought to stick close to the statutory language. As far as my learned friend's headline case is concerned, the position was one whereby she indicated that the relevant section, section 90C, should be taken as solely for the purpose of determination with the incurring of the expenses by the candidate or the candidate's agent. The position as far as the prosecution is concerned is as follows, that it has always been the position that, to use slightly different language, there is a hypothesis stated in subsection 1, a determination in subsection 2, and a requirement to treat in subsection 2. That is the language which is actually deployed. And the position can be seen as one which cannot be sustained in terms of my learned friend's submission when she says that it merely is a determination of something which has been incurred by the candidate or the agent. If the court would kindly look at, please, MS page 446, subsection 2, the treatment is treatment as incurred by the candidate, 2A, about a quarter of the way up the page. Treated as incurred by the candidate, and the candidate's agent is then obliged to make a declaration. If one goes back to section 81, one sees that a return as to election expenses, 1A, page 436, is of expenses incurred by or on behalf of the candidate. Now, in this circumstance, nothing has been incurred as a matter of fact because of the hypothesis by the candidate or the candidate's agent. Consequently, the treatment merely requires it to be treated as incurred by the candidate. If my learned friend were correct and it had to have been incurred by the candidate or the agent, why is that language there simply used in those terms? It was used because Section 90C was the requirement that Parliament imposed to get certain expenditure incurred by others into the declaration being made by the candidate's election agent. The position as far as the Neil report is concerned and the Electoral Commission's advice is concerned is as follows. One, the Neil report was some 2 years prior to the legislation and should accordingly be treated with a certain amount of caution. Second, the Electoral Commission advice my learned friend referred to was for the 2008 by-election. The later advice at 1011, MS 1011, does distinctly deal with the question of incur in terms which are marching in hand with the observations I made to the court this morning, namely that incurred indicated precisely that one had incurred some liability. My learned friend sought to place reliance upon the legislation dealing with parties and dealing with the European Union. As far as that is concerned, if I may respectfully sidestep that, because I respectfully say that the court is actually concerned with this representation of the people legislation, but it can be observed that the party legislation and the reliance upon the European Union Referendum Act must be misplaced, in my respectful submission. The mechanism was that the 2000 Act demands that national referendums should come to be pursued in consequence of an individual bill for each referendum, and that led to the 2015 Act. And I would respectfully say that it is not sensible to seek to construe the Representation of the People Act 1983 by reference to the 2015 legislation, which was necessarily unique. If there is another referendum, it will not be under the 2015 Act, but under some different, yet to be enacted piece of legislation. My learned friend this morning indicated that there was an importance in considering the facts of this case, and then proceeded to tell us about Mr. Farage and UKIP and South Thanet. The position as far as Mr. Farage is concerned is entirely, in my respectful submission, by the by. The position that we're concerned with in terms of the facts is as presented to the court this morning, and I showed the court the information which is based upon the evidence that the prosecution are able to adduce. And with the greatest respect to my learned friend, the approach in seeking to say that others would walk into an undeserved criminal liability is wrong. So that she, for example, referred to Mrs. Bowman and said, what happens if she arrives in, let it be, South Thanet, and then has her meeting taken over, as it were, by the candidate. The position is quite straightforward, with the greatest respect, in connection with her. The situation under Section 75 is that there is an inhibition on expenses being incurred by any person other than the candidate on account of certain matters, to which she is now subject to the provision giving her £700. A question as to whether or no what she did came to fall within 90C is a secondary question which may arise on the legislation, but does not bear upon her ability to pursue her interests as she wishes to do so, pursuant to the judgment that she obtained from the European Court of Human Rights. And the only thing which, in my respectful submission, matters is to get back to the terms of the legislation 90C and 90ZA. And in my respectful submission, the position about 90ZA, as appeared to be a consequence of the discussion between my learned friend and my Lord Mance, is that 90ZA managed to and did replace both 90A and 90B. When 90A and 90B were in existence, the schedule was not present. And 90ZA has done the task which is necessary to be done. And so the sole task that comes about for this court is in connection with 90ZA and 90C, on which the court already has my submissions. There were some other incidental matters which my learned friend touched upon. One such was the question of donations. The court may have observed that the section dealing with donations, section 71A, precedes the group of sections which deal with election expenses. And when one looks at the Act in the Queen's printer's copy and so on, one sees that particular categorization very clearly made. It precedes that. The purpose behind the introduction of the inhibitions on donations was simply this, the court may have observed that donations takes one to Schedule 2A, and the prohibition in paragraph 6 on Schedule 2A, which is a prohibition on accepting donations from certain people, because there are permissible donors and impermissible donors. They are set out in section 54, subsection 2 of the 2000 Act, which the court, I don't think, has amongst its papers.
Section
54 of the 2000 Act, and they consist of a long list of what may be described as UK legal persons. In other words, the purpose of the donation provision was to avoid foreign financing of elections or campaigns at elections. Ah, yes, I see. And in the guidance, a shortcut to that is given at MS page number 1107. You must only accept donations from a permissible source, and then it sets them out, registered on UK electoral register and so forth. So the idea is, please can our election money come from within the United Kingdom rather than from elsewhere. It doesn't bear upon this particular matter, whether as suggested by my learned friend or at all. My lady, that takes me to 4 o'clock. Unless there's any other particular matter I'm reminded of, or unless there's any matter that the court would wish to canvass, I'm anxious to adhere to my timetable.
You've all done extremely well in adhering to a very tight timetable, quite apart from extremely well in presenting this tricky conundrum to the court. We will now take it away with us, apply the wet towels, and come up with an answer as soon as we possibly can.
Can I
Ms.
take it the
Montgomery?
court will require that spreadsheet of the
It will be extremely
well,
helpful.
we'll do that.
Yes.
Very helpful, thanks.
Yes. Thank you very much. Yes. And having said all that, the court will now adjourn.